Welcome to Courtroom Advocacy for Beginners. Your presenter is Hugh Selby. The fact scenario used as the background for explanations and demonstrations is the first verse of the nursery rhyme Jack and Jill. It's used because most people know of it from childhood and it's readily adapted for both civil and criminal court cases. But the nursery rhyme has evidentiary shortcomings that also make it an ideal learning tool. So much of what we say in everyday conversation is broad description. But in court, the art is to bring out relevant detail. Each demonstration clip helps you to improve your skill by showing some aspect of courtcraft with voice overlay critique. So, each voice overlay explains what is being done and suggests a practice routine for you. The voice overlay also enables you to then critique your own practice attempts. A trial is a retelling of an event or a series of events, told from various perspectives. Trials are dominated by spoken accounts from witnesses. Of course, there are charts, photos, maps, even film clips that are used at trials, but these are rarely the primary sources. The result is that our trials are out of step with our visually dominated lives. An advocate, as a persuader, should find their audience's viewpoint and start from where their audiences are. A courtroom is the place where lawyers, advocates and judges, naturally filter facts through legal tests. Jurors, however, not being law trained, filter facts through their life experience. All communication is influenced by the environment in which it takes place. Hence, any trial is influenced by the atmospherics, which includes community perception, for example, a prejudice against a person or a group, as well as the layout of a courtroom and the physical and presentation characteristics, such as attractiveness, confidence, voice, of each advocate. Let's look now at what can be done with the courtroom space to make the speaker a more persuasive advocate. This is the point of view of the judge or jury. This is the point of view that must be served by both witness and their advocate. Sightlines and occasional eye contact with the decision maker are important for engaged conversation and persuasion. This is the common but wrong way to present. The witness needs to respect the decision maker, not their lawyer. This ear to ear of the advocate and the witness, and with both with their eyes towards the front, respects the decision maker. The advocate who has a credible witness should build that witness up and diminish the advocate's presence. Compare and contrast these various head position combinations. Only the witness head up and advocate head down ensures that the decision maker is drawn to the witness rather than the lawyer. Appearing confident aids persuasion. Signs of anxiety suggest a lack of confidence in self, in the client, in the case, or all of those. A common masking device for anxiety is to put your hands behind your back and twiddle your fingers. But this leaves the problem of how to turn pages or be active with gesture. For both advocate and witness, we want to move telltale anxiety movements from above the waist and down into the toes. This shot shows fingers moving. Move your toes in the same manner as it shows your fingers and sync your toe movement with your voice speed. The guide is toes move slowly, then mouth opens and you speak slowly. You need to experiment with how to position the furniture, for example, a lectern or your chair, at or near the bar table. Get others, who should always be sitting in the decision maker's position, to tell you whether you should be behind the lectern, away from it, or with one hand touching it. One of these positions is bound to be better than the other two for you. If you are one of those people who are better off the lectern, then you need to know whether the bar table chair should be in front of you, so that is between you and the bar table, or behind you, so that there is only the table between you and the decision maker and the witness. Courtroom audiences need to trust advocates. That's why an ethical approach is the first case component. An advocate who is not trusted in the courtroom is less persuasive. Professional ethics for advocates lay out our common ideas about what is fair play. The ethical principle that will guide every aspect of this training is that the advocate will neither by question nor statement suggest to the decision maker or any other audience a state of affairs that the advocate knows to be false. The case we present at trial is someone's story. That's a story that is refashioned by words to paint pictures for the courtroom audiences. As advocates, we must be able to visualize the scene that we intend to recreate with a witness. Once visualized, we must, in our opening statement, in our closing argument, and in our questioning, pass those images into the hearts and minds of our decision makers so that they see what we want them to see. Prioritized delivery means that using case analysis, and we discuss this concept next, you are able to present material following the guideline. Best opens, second best closes, the rest in between. Summarized, we have the equation for the components that you see here. Now we move to the case analysis, which puts content on the parts of that equation. Adversarial system means a contest with winners and losers. To run a case well requires the ability to run both sides. Developing the ability to anticipate your opponent is essential. Consider both physical sports and mind sports such as chess, where the same anticipatory requirement applies. Case analysis is a thinking process that is best displayed on a large board. Note, not a small desktop computer or tablet screen, because on a large board it's for our benefit and that of our team, those being our witnesses and any fellow lawyers or paralegals. The process of case analysis is deliberately non-linear, so that prioritization can be decided quite late in the analysis, rather than inadvertently decided too early by a list. Prioritization is essential for persuasion. It gives us the topics that we'll use and the order in which we'll develop those topics with witnesses in our opening and in our closing argument. As advocates, we either establish the proof or prevent the proof of specified legal elements, be that for a civil or a criminal case. Now, get yourself a large sheet of paper or find a large whiteboard, because you're now going to put up the elements of the following case. The case is that Jill is accused of assaulting Jack and causing him to break his crown. So, on your paper or on your whiteboard, randomly put the following bits of information. First, the assault, that Jill has contact with Jack. Second, consent, the lack of it. Next, the injury, which is causing the broken crown. Next, intent, for which the evidence is that Jack felt Jill put a stick between his legs that caused him to fall. Finally, go to motive. The argument will be that Jack and Jill had argued just before they started up the hill. As I said, put these up randomly, like suns in outer space. Around those elements, put the facts that we have. We find, as soon as we use the Jack and Jill rhyme, that we have only generalised descriptions rather than the facts that evidence those descriptions. This happens a lot when taking witness statements. Review the slide of the unknown aspect of Jack and Jill's journey. What other facts do we, or our opponents, need, and from whom can these facts be obtained? Put around the relevant legal element those facts you've got and those facts you want. Sometimes facts will belong to more than one element. If so, draw a connecting line to show that a fact is used for two or more legal elements. Now, as a separate but necessary task, create your own comprehensive, multi-layered, that's one witness per layer, timeline, as the only way to check the extent to which the witness statements are inconsistent as to when events occurred, where they occurred, and who was present. Such a timeline will show the strengths and weaknesses for you and your opponent from the facts that you can elicit from your respective witnesses. Apply evidentiary and procedural rules to the facts by identifying the means, for example, direct evidence, an exception to the hearsay rule, judicial notice, to name just three, to have the evidence admitted in the trial. For example, who's telling the Jack and Jill story? If it's not Jack or Jill, then from what vantage point, if at all, did the storyteller see these events?
You have established the distance from the bike path to the hill, but who, if anyone, did you see?
There was a man and a woman.
And did you recognise the man and woman?
Yes, I think that I used to take a bus with them when I was in primary school. I believe their names were Jack and Jill.
You have established that these two people were Jack and Jill, but could you tell me, or could you tell us about the weather?
Yes, it was raining.
And how did you feel while you were riding your bike in this weather?
Well, as you can imagine, it was quite slippery. I had to watch out for puddles just so I didn't go out of control, that sort of thing.
Consider the case atmospherics. Who does the crowd favour? Is it Jack or is it Jill? How can that favouritism be used? How can the lack of favour to the other party be met? Identify the strong and weak facts against each of the legal elements. Whether a fact is strong or weak reflects the credibility of the witness or witnesses, through whom it will be put before the decision maker. Credibility reflects not only character attributes and reputation, but also opportunity and memory. Reputation of a particular witness and the atmospherics in the courtroom are inevitably interwoven. Using those fact evaluations, consider which of the elements you've put up on your sheet or the board will be easy to prove or disprove, and which will be less easy or difficult to prove or disprove. Apply the Persuasion Guideline. Start best, finish with your second best, weak stuff in the middle, to prioritise the order of each and all of the legal elements in your closing argument, the order in which you will call your witnesses, the topics that you will cover with each of your witnesses, and how you'll prioritise the facts and topics to be mentioned in your opening address. By the way, you cannot escape some guesswork in this process, and you cannot escape making errors, because your information is never complete and the future always brings the unexpected. One thing you can be certain of is hindsight is always useful, if never comforting.